Yes, tell me, please.
Okay. No,
Good morning.
fine. Good morning. Good morning.
Yes, yes.
Yeah.
I'm ready now.
You two, should we wait or should we start?
Sir, you can start, please. I have messaged you.
Okay.
Yes, sir. You can start.
Good morning to all of you. I have a pleasure in welcoming you all for today's session. The today's session is, as you have seen, it is actually secretarial due diligence. Due diligence is a very, very vast subject, because in the recent past, the due diligence has acquired much importance because there have been a lot of foreign direct investment, there are a lot of merger and there are acquisition. The way of expansion is taking place in a larger way by merger and amalgamations. And not only that, ever since we have changed from the controlled license regime to the open regime, then what happens is there are various people who actually put their activities at different places. They are also consolidating the activities, doing it. So merger and amalgamation is in a very, very large way, which is happening. Apart from that, companies are going for IPO, companies are interested getting into the joint venture arrangement. All those things are there. So whenever the investment takes place, the person is actually interested, the company, that is the target company in which you would like to invest, you would like to ensure about the company. What has been the past performance? What is the company's present status? What is going to be the future prospects of the company? He may have his own plan relating to the marketability, expansion, product, or compliances, or financials, or taxation, etc. And not only that, they also will be more interested in looking into culture, ethics, and behavior of the people, because two different companies, they merge together. It is two different set of people with the different values they are merging together. So ultimately, the value, ethics, and culture should emanate one for the company. So all these concerns are very much there when we talk about this merger amalgamation. Because of that, what people do is people actually conduct the due diligence about the target company. And one more thing is there, especially with the financial institution and banks, more so with the banks who actually lend the money. Because the money lending done by not the bank's own money, it is the money which has been saving people who are put the depositors, whose money is there, it is a public at large the money. So when they are lending the money, they will also safeguard the money which is lent by them. So from that perspective, they also ask to conduct a due diligence about what is the company, what is the assets they are holding it, what is the borrowing so far they have done. If they give the borrowings, then whether they have the sufficient funds to back up to give the security. Normally, this has been done by the banks. In fact, a lot of company secretary people, they are doing the due diligence only for the banks, which is one of the major practicing area, which also you may be aware of it. So the subject is very, very vast, and the subject run through financial due diligence and legal due diligence, operational due diligence, marketing due diligence, ethical, culture, behavioral due diligence, HR due diligence. So many areas are there in the due diligence. But today we will not be able to discuss all the type of the due diligence, although our presenter will be touch upon the different type of the due diligence, more particularly because we are concerned with the secretarials. So we will be concentrating on the secretarial due diligence. That is mainly what are the secretarial functions relating to things that she will be actually concentrating elaborately, while she will be touching upon other questions. And we have a very eminent panelist with us, Mr. Raghav. You all may be knowing it. I don't think I need to give an introduction to him. He will actually kindly agree to share the practical difficulty, the practical aspects of the due diligence when we are doing it. So he will be actually sharing his valued practical experiences, which will go in a longer way to helping the people here to understand the subject, rather getting confirmed what we are already knowing it. So that is all I want to say about this due diligence subject. And I would request Mr. Raghav to add a few words before our presenter starts. Over to Raghav, please.
Thank you, Balkrishnan sir. It's a pleasure being here. Thank you for having me in. And I would like to state that today's topic, I think, is quite interesting. It is quite exhaustive. If we have to spend time on, every aspect of it, I think it will definitely take a session in itself, various aspects of due diligence as such. But in today's context, I think, DD is more of art and science, and it is both legal requirement and a commercial requirement, if you come to think of it, as you rightly said. So the growing business which is happening in India, the investments, foreign direct investments, private equity, venture capital, all of that requires this exercise to sort of become mainstream and full-fledged. There's always something more to sort of look for when you complete this exercise. Maybe I can, the way we can do this is we can keep this interactive. If there are questions, I can take them, or whenever Aditi is pausing for me to come in, maybe I'll do that as well. And then maybe in the end, I will also sort of talk about a few of the other areas of due diligence other than legal, compliance, secretarial, which sort of is carried out when an investment is made, and the utility of that exercise in terms of how that is looked upon and what the takeaways and how that is used at the end of that exercise.
Thank you very much, Mr. Raghav.
Thank you, sir.
For the information of the people who may not be well aware of Mr. Raghav, I would like to say Mr. Raghav has been a experience of almost more than about 2 decades, if I'm not mistaken, and he is currently a managing partner and managing the Everstone private equity legal compliances, and also he assesses the risk management work there, and he looks after the portfolio compliances which are actually required there. In fact, he has got a vast experience in the area of the legal compliance, risk management, and regulatory issues, etc., and other things and all. And he was also associated with the JP Morgan in a earlier, and also HCL Tech. And his vast experience will definitely bring out a lot of practicality to us, and we will be very glad to have him with us.
Thank you very much.
Over to you, can please.
Good morning, everyone.
Good morning.
So today's topic of deliberation is secretarial due diligence. When we talk about India as a country, India is a country wherein every new day a new company is incorporated. With the incorporation of companies, a new line of business comes into picture. And with each type of a business, there is a business risk which is involved. So understanding the kind of risk that is involved in a particular type of business is very, very urgent. Business risk can be defined as the factors, maybe internal, maybe external, that somehow it affects the company in achievement of its objectives. Here, when we are talking about objectives, not necessarily only financial, but it can also lead to hampering the reputation of a company. It can also lead to non-association of stakeholders with non-compliant companies. So the business risk differs from company to company and from industry to industry. So having understood what this business risk is all about, identification of this business risk and dealing with it accordingly becomes very important for any company or a business entity. Now, the procedure we follow in order to understand the business risk is due diligence. Due diligence is not a very new concept, but yes, it is a detailed analysis, detailed investigation of the records of a company that helps us to understand the market standing, the financial position, and the risk that it might carry with its nature of business. So the areas of concern and the business risks can be identified by this process, and it is an investigation into the records of the company to understand if a forthcoming business transaction is going to work in favor or not. Now we have understood what this due diligence is all about, talking about reasons for conducting due diligence. As Bala sir has already focused on a lot of points why when a business entity takes into account due diligence, few of the important areas where due diligence comes into picture is acquisitions, mergers and amalgamations, initial public offer, managerial remuneration, joint venture, valuation, defense in litigation, lending institutions, banks, and many other similar things. Now, when we are talking about acquisitions, mergers, and amalgamations, one of the very important and a lengthy processes in a merger and amalgamation deal is the conduct of due diligence. Now, what is the importance of a due diligence in this entire deal? When we are talking about acquisitions, we are talking about mergers and amalgamations, we are basically focusing on two different entities who are merging or amalgamating within themselves to look after a common objective. Therefore, here it becomes very important for the buyer to understand if the seller is true in its claim. Here, claim basically refers to the target company's business, the assets, the liabilities, the capabilities, and the financial position. Similarly, if we talk about an initial public offer refers to when a target company or an issuer company wants to invite the public to subscribe to its shares. So initial public offer is a mandatory, the due diligence process is a mandate in an initial public offer. SEBI guidelines talks about having a mandatory due diligence when a target company is going into a IPO. Whenever we are going into filing a draft red herring prospectus, it becomes very important to understand that the company is compliant with all the laws that is applicable to it. Now, talking about managerial remuneration, what point does due diligence have with managerial remuneration specifically? Now, managerial remuneration, as we all are aware of, is something which is calculated on the net profit. It is a percentage that is given to the directors, as has been prescribed in the Companies Act. Only up to a certain level a managerial remuneration can be given. Here, when we are talking about net profits, or for that matter, the financials of a company, it becomes very important to understand by way of a financial DD particularly, that whatever has been portrayed or whatever has been stated in the financial statements are true and fair in the right spirit, and the managerial remuneration that is being given out is understood to be correct. So here, under these circumstances, due diligence comes into picture. Now, when we are talking about a joint venture is again when two corporate entities are joining hands for a very common objective. So here, to assess the operational and technical capabilities of both the entities, it becomes very important for the entities to undergo a due diligence process. Each party that is entering into this joint venture would want to understand and would want to protect its interest. It would like to protect its involvement in the joint venture and will want to assure that every other party will be able to fulfill the obligations that it is supposed to fulfill. So when we are talking about a joint venture, here also the due diligence comes into picture. Now, talking about valuation. Valuation has become a very common phenomenon now. Many companies talk about valuation. Many companies go into valuation of shares. So whenever a company gets into a valuation, in similar lines, a financial DD is to be conducted to understand if the financials are understated, overstated, or they are in actuarials and they are in compliance or not. Now, next is defense in litigation. So how can due diligence be a defense in litigation? Very important point to focus here is due diligence is a process which can be also undertaken by a target company by itself. Not necessarily that a company needs to enter into a joint venture or a M&A or a acquisition, but the company can also get itself conducted, can conduct a due diligence on itself to understand whether it is compliant or not. So when we talk about a defense in litigation, it becomes like if the company is coming across any kind of a litigation matter, the company can take shelter under this, stating that we have been, due diligence has been conducted on us and we are compliant in all the laws that is applicable to the company. Here in litigation, we will not only focus on the Companies Act, but also Sales of Goods Act, the Transfer of Property Act. We are aware of the concept of caveat emptor. We are aware, let the buyer be aware. Now, how this thing can be connected with due diligence is, whenever we are entering into a business transaction, two parties, they are entering into a business transaction, may it be for a merger or may it be for sale of companies, they need to understand that both the companies are aligning their objectives with each other. So here, when we talk about caveat emptor, it is a concept wherein the buyer has the responsibility to understand the sustainability of the goods that is the question of sale or purchase. So here, the defense in litigation can be taken when we conduct a process of due diligence. Now, talking about lending institutions and banks, whenever banks or lending institutions are lending out money to the public or to any other corporate entity, they would definitely be in a position to understand the repayment capabilities of the party to which the money is being lent out. So here also lending institutions and banks can undergo and can conduct a due diligence procedure to understand whether the money is in safe hands or not. So many other similar conditions or circumstances are there where we can conduct a due diligence.
1 minute, Aditi. Aditi actually spoke about the other applicable laws to the company. And many of you may be aware, company keep on acquiring properties, company keep on acquiring land and buildings, many things. If you look at it about 30 years back, it is a practical experience I would like to share with you. 30 years back, I was working in a company as a head of internal audit. Routinely internal audit, whatever we are doing it and all, apart from that, I actually wanted to suggest to the management, do we have a valid title deeds for all the assets what the company is actually holding? Because the company was holding in a manufacturing plant at Pune, something around 25 residential plots which has been allotted to the employees. In fact, these plots have been actually given, by the Maharashtra government for the industrial promotion purposes to the SDFC company, who has been a developer, that are SDFC developers. And in fact, the SDFC developers have developed this company, and there is a agreement has been entered initially between the company and the Maharashtra government for the land sale. And subsequently, the SDFC developer has been given for develop the property and build the residential plots and hand over to the property to the companies. And once that process is completed, yes, tripartite agreement is required to be entered between the Maharashtra government and the company and also the SDFC developer, virtually transferring all those residential plots in the names of the company. But somehow there in the whole process, what has happened, company has got the land, SDFC developers built the residential plots, but the tripartite agreement has not been made. Really speaking, the title deeds of the ownership of the flat never transferred to the company. Although it has been, land was standing in the name of the company, they could get the what we call the water bills, electricity bill in the company's name. It has been actually going on. Almost 2 decades later, 20 years later, the company wanted to consolidate the operations. And before that, we were actually running the check. That is the time when I was running the check. When I was running the check, I found the title deeds are not there. If the company is consolidating, if the company wants to give it up and they want to move to some other places, when you don't have the title deeds, how do we dispose of the properties? And then when we started running it, it was very difficult to find out what has happened some years back really. Because preservation of the documents, what you are talking, people normally preserve documents for 8 years and beyond that they don't keep, etc. Nothing. It was a very, very hell of a job for me. Finding out the document itself has taken almost about 6 to 8 months. What has happened to the transaction, to understanding a thing, that has also happened, because when these things happen, I was not there. Subsequently, I joined the company. Then after finding out all the things, then you know the hassle of going to the government department, getting the things set right, everything. It was a very, very big hassle. Then ultimately we have to run to pillar to post. And finally, when he found a HDFC developers has actually closed, it has been merged with the HDFC Housing Finance Corporation. Then we'll have to the Housing Finance Corporation, we'll have to get the document, they wanted the documents, all those things were there. Documents were never available to one place. We'll have to run from one place to other place. Government kept on shifting the document. Finally, we'll have to go to somewhere near Kalachoki and find out the document from there, go down. Then later on, we got to enter the tri-party agreement. Then the hassle which came, what is the stamp duty payable? Because if 20 years back, if you would have executed, we would have hardly paid the nominal stamp duty of 5,000 rupees per flat. Now, after 20 years later, when you are doing it, what is the stamp duty payable? That was a big question which has actually come. And if you actually get current rates of the stamp duty, it is running in crores of rupees. Then finally, we'll have to go to the adjudication of the superintendent of stamp, and we'll have to explain whatever the thing. Then we'll have to tell them virtually the transfer has taken place, only the paperwork remained to be done. It is only we are regularizing the paperwork. With the result, ultimately the superintendent adjusts the same amount of the debt duty with some nominal fine, etc. So really speaking, if we don't keep our house in order, what you're talking about the due diligence, it is going to have a lot of problem. And when we do the due diligence, these things comes out, then setting right will actually call for a lot of time, energy, money, everything. Instead of people concentrating on the business, they will be concentrating on the litigation issues.
It's a very valid point. If I can just add one more relevant point over here, in addition to what Professor just mentioned. In high-stake investment situations in today's context, now, if these things are not kept in order, if the housekeeping has not been satisfactory, and then if the investor or the buyer of the asset insists that he wants to see certain things to be in place, there is a risk to the transaction itself, right? So you are basically losing out on the opportunity of a deal, because if something is prerequisite for a transaction to take place, and because of our ignorance or lack of seriousness about some of these things, if those things are not in place, then maybe investments worth thousands of crores will be at stake. The buyer cannot indefinitely wait for you to fix these things, and in 6 months the world will go upside down. So that's another point I wanted to add.
Added to this was, what has happened is ultimately the company management was got very upset with the statutory auditors. What are the audit you people have done? Not even check the title deeds, which resulted actually changing of the auditors. Yeah, go ahead, Aditi.
Okay. So now talking about due diligence in India. So particularly when we talk about our country, due diligence is not a very new concept. Its existence dates back to the 15th century, and it was introduced way back in the year 1930s. So we've already discussed on the points like due diligence is generally performed before any investment is made, before sale of an asset, funding, or when we are entering into any kind of a partnership deed or a partnership agreement. So during this process of due diligence, what is understood is the financial, the legal, and the compliances, the secretarial aspects of a company are investigated, they are reviewed, they are inspected, and finally a conclusion is drawn that if any risk is prevailing within the business unit or not. So the purpose of this entire due diligence is not basically to learn everything about the business, but to understand if there is any deviation from what has been stated, or deviation or non-compliances that we might have come across.
Yeah, so Aditi, if I can add one point here. So, diligence is, as I said, is both art and science, and both legal requirement, contractual requirement, as well as commercial requirement, right? Now, if I'm buying something, I'm duty bound to examine, get into final details. That's what we just discussed, coming from Sale of Goods Act, Transfer of Property Act, SEBI requirements, all of that, right? As managers of money, like banks and financial investors in equity, there are these contractual commitments as well given to the investors that the investment manager is required to undertake. So if some investment is being envisaged, before it's done, it's sort of a contractual requirement to undergo all the commercial diligence, legal diligence, tax diligence, financial diligence, and several other sort of subsets of them. Now that's the reality of today's commercial environment, right? Coming both from requirements as well as commercial requirements.
Yes. So now talking about the aim of the due diligence process. Having discussed the reasons why this due diligence has to be conducted, so the aim is very, very clear. Now, the aim of this entire due diligence process is to understand the business operations, to discover business opportunities, to take a view into the concealed facts. Now, here when we are talking about concealed facts are certain things which are not known to the stakeholders. We are in a position, we are not able to understand every detail in which a company is running its business. So through this process of due diligence, we understand the ins and outs that takes place in the management of an organization. And one very important aim, or rather an aspect of due diligence is, it not only takes care of the current situation, but it takes into consideration the past, the present, as well as the future aspect that might affect the commerce or the market standing of a business entity. So due diligence process basically helps us to understand business goals. It helps us to understand the reasons why, because the business is existing as on date, and it helps us to understand how well a company can perform amidst the risks which is prevailing. Now, talking about due diligence, we've already deliberated on how vast this due diligence is. So the topic of due diligence is as vast as a sea. So different types of due diligences are there depending on the kind of transaction that an entity is entering into. So when we are talking about transaction here, financial due diligence comes into picture when a financial performance or the financial background of a company is to be considered. Legal due diligence comes into picture when the company is entering into any agreements, entering into any contracts. Similarly, a tax due diligence, operational due diligence, intellectual property due diligence, commercial due diligence, information technology due diligence, human resource due diligence, regulatory due diligence, environmental due diligence, secretarial compliance due diligence, sector-specific due diligence, and many more to add on to the list. So specifically, if we pick up single type of a due diligence, it is depending on the outcome that the target company is seeking by the through this process. So here, when we are talking about the outcome, like I said, financial due diligence. If the company is wanting to understand the financial standing, it would like to go into a financial due diligence. So it is basically financial due diligence is a crucial assessment of the financial health of a company.
1 minute, Aditi. When you are talking the financial due diligence, legal due diligence, or tax due diligence, it does not mean that due diligence is done only with respect to financial areas. The due diligence is actually done by and large for all the aspects of the company, but the main focus is actually financial area. Because the whole idea is the aim of the investor, if he wants to be, profit oriented, he is more concerned about the gross margin, he is more concerned about how we manage our business, how we manage our funds, etc. He will be more interested knowing about the financial. But on the contrary, if the people wanted to do the business, but at the same time they want to be a what you call highly respected compliant company, they will definitely look into the legal aspect and the compliance aspect of it, and they will say, okay, the focus should be on the legal and compliance. And again, tax, when it comes to, you may be knowing the tax is actually very, very vast subject, because you may be knowing many companies, they do the window dressing. Contingent liabilities are shown as the actual liabilities are shown as the contingent liability, etc. Now, for example, the larger factory inside, if they are wanting to make a inner road repair, which is there within the organizations, they wanted to act very smartly. So although they will be repairing the road, which has to go at the profit and loss account of the expenses of the repair, but they will actually say it is an asset, new road made. It is possible. So there are a lot of issues which actually come out, which actually tend to have a tax implication later, because tax is not assessed year to year. You may be knowing there are a lot of assessments are actually pending for the companies. Matter goes to the income tax law tribunal, it goes even higher ups, etc. And all those things are all there. You know, in the Vodafone case, what has happened, the litigation which is going for a very long time. Finally, it has to be get settled by the Supreme Court. So with the result of all these things, what is happening is it is the interest of the investor, what is the focus area he wants to concentrate, that will actually determine the more or less the type of the due diligence. But it does not mean other aspects will not be looked into. Other aspects will definitely be looked into, but more focus will be given on this particular area. That is where we are talking about the different type of the due diligence.
If I can add here, I think just in addition to what Professor just mentioned, so if I'm the buyer of a, let's call it as a company with an operation spanning over different geographies and various different business verticals, right? I am buying this company. Now I'm paying, let's say, 100 rupees. Now, where do I start? What am I buying it for, right? From the buyer's perspective, to know everything becomes very, very important. Financial, commercial, legal, tax, reputational, all of this has to be looked together. So if you start with, let's say, financial statements, you may not get the full picture, because, that's just a past historic record of certain aspects. Now, whether they are real, they are sustainable, whether they are, something which can be relied upon, all of that will be clear, and whether that's something that can continue to be the same going forward will be unearthed during this exercise. When you speak with people who are management, you speak with outsiders who could be customers, who are vendors, who are suppliers, I will talk about that maybe towards the end of the session in terms of what are the aspects that typically investors look at when they are assessing various different aspects of the business, like tax, legal, financial. But the point is, if you don't apply your mind and then go through that exercise, it would increase the cost of doing business. All your assumptions that you may have entered into with may go for a toss, because just relying on the audited financial statements, whether for the current year or the last 3 years, will not give you the full picture at all. That's just the starting point, right? So that's where this entire exercise of DD becomes very, very critical.
Operational due diligence. Operational due diligence again looks into the particular operational areas of a company. Intellectual property are the intangible property. So the due diligence relating to intellectual property. Then we come across commercial due diligence. We come across information technology due diligence. Information technology due diligence is also linked up with systems audit. And this is a kind of a due diligence wherein the IT infrastructure of a company is detailed analysis of the IT infrastructure of a company is taken into account. Now, talking about human resource due diligence, human resource is the most important area that is one of the most important areas in a business entity. So human resource due diligence is growing in importance with each passing day because the laws relating to protection of employees at a workplace, the laws relating to taking care of their needs is growing in importance. And hence, this human resource due diligence basically is a very extensive process wherein all the documentations relating to the employees and the management is checked. When we talk...
1 minute, Aditi. When you talk about the human resources due diligence, it occurs very much importance when we talk about the merger amalgamation. When the merger amalgamation takes place, the very first thing what happens in the target company is people are, after all, we are all human beings, we are not machine. So what happened? Oh my God, this company is being taken over. What will happen to my position? Whether I'll be holding the same position, whether I'll be getting the same salary, whether I'll be in the same grade, whether my reporting position will be same or it will be different, whether I'll be demoted, or not only that, whether my job itself will be at a stake or whether I will be there, I will not be there. All these questions will actually will coming. Another thing is there will be highly intellectual people whom the company would like to retain. If the communication doesn't go down the line proper, there is always a chance of losing the expert people after the merger, which is actually seen in many companies because of the communication not taken place. Because the communication is very, very important, the merger and amalgamation, whether it is the good news or the bad news, it has to be shared across. Then only people will know what is the right position. That is another thing. The human resources definitely acquire the very much importance because post-merger, the people retaining, especially the talented people retaining with the company who will be useful, the due diligence would have thrown out the companies having a very expert people by which the business is being run. If those very same people are not going to be there, the very same people are leaving the company, then the whole purpose for which the business acquired may not serve the things. From that perspective, the human resources due diligence acquires very, very important, which I would like to make a point. Yeah.
Absolutely, sir. Sir, in similar lines, if we talk about regulatory due diligence is also gaining importance with each passing day.
High risk area. Because if something we missed out tomorrow, if the ROC take an inspection, if they come out, then there is a lot of non-compliances due to which rectification will become a very big problem. There could be condemnation, could be possible. There will be compounding application required to be filed. There can be a prosecution issues also can plague. It is a very high risk area.
Absolutely, sir. So because we are living in a amidst a very changing regulatory landscape. So taking care of the changing regulations and the amendments coming in on a very regular basis becomes very important for a business entity. Now, when we talk about environmental due diligence, again, environmental due diligence is also becoming very important. Why? Because previously, as we knew, that profit was the only motive of business entities. But now at the same lines, as they try to earn profits, they also have a responsibility towards the society. So when we talk specifically of an environmental due diligence, we have to understand how they are not hampering during the course of their business. They are not hampering the environment in which they are operating. Otherwise, again, they would be subject to penalties, and heavy penalties is being charged.
What heavy penalty? Company will be closed down if they don't comply with the environmental laws.
Shutdown.
Because I know in Pune, there was a paper manufacturing company which are actually discharging their waste in the nearby river. which has gone unnoticed for years together, and the people have taken up the issue. The company was actually closed down. It could not open for an extra 1 year unless until they actually set right everything, they given the assurance, etc. Very, very high risk is there closing down the business. Because especially it is so with the chemical industries, hazardous industries, other industries is very sure, because they allowed to put up the effluent treatment plant, they allowed to treat. Because the groundwater, which is actually discharging the water, if they travel nearby villages and well, it gets mixed with the well water, which is used for the drinking water, that will create a lot of problem for the human being and animals, etc., who use the water for drinking purposes. This is a very high dangerous area. So environmental is very, very important here. I have seen many companies which is actually virtually closed down. And you all will actually recall it. There is a Ganga tannery case. Initially, the Mehta versus Government of India, which has actually taken out, which rocked the country. That is one of the very judgmental thing which has been delivered by the Supreme Court of India in this country. So that sort of the risk is there in case of the environmental. Yeah.
Now is secretarial or compliance due diligence and sector specific due diligence. So having understood about all the types of due diligence, due to paucity of time, we will now be concentrating on the crux of the topic, that is secretarial or compliance due diligence. Now, when we are talking about the secretarial or compliance due diligence, we are basically focusing on the laws which is applicable to the company. Whenever a company is incorporated, by default, it is the Companies Act under which a company is incorporated. So all the provisions which is there in the Companies Act has to be mandatorily complied by the business entity when it is running its business. So here, a secretarial or a compliance due diligence is basically checking that all the laws that is applicable to the company is complied with and they are running in compliance. And in case of any report or in case of any findings, we have to make good the loss. So now we talk about the difference between the secretarial audit and due diligence. Now, very, very important aspect here to understand is once secretarial audit is already in existence, Section 204 of the Companies Act prescribes certain classes of companies which are mandatorily required to undergo a secretarial audit. But then why due diligence? Now, what we have to understand here is, now due diligence has also become a mandatory requirement in many such events taking place. For example, as we discussed in an initial public offering, the SEBI has mandated the performance of a due diligence. So secretarial audit and due diligence are now two different things, and it has to be performed at two different points of time. Because when we are talking about secretarial audit, we are talking on historical data and it is a post-mortem analysis, because secretarial audit is something that we conduct to understand the compliances which have already been done. But due diligence is something which is required for a future decision. To take an informed decision, a buyer or a prospective investor takes into account this process to understand the future growth prospects of a company. Now, if we talk about the repeatedness, then secretarial audit is a recurring event only in case of companies where it is mandatorily required to do a secretarial audit. And in case of a due diligence, it is an occasional event which takes place only when certain events are about to occur with that business entity.
Ms. Patnaik, can I ask a question at this stage? Shailesh
Sure,
Yes, yes.
Sure, sir.
You see, in the course of your talk, you did mention about SEBI mandating due diligence at various stages. I'm sure it would be in the case of an initial public issue. It could be in the case of a rights issue, and maybe also in the case of mergers and amalgamations. I don't know about the last one. Now, this mandated due diligence, does it cover secretarial due diligence, or does it mandate the merchant banker to do due diligence? That means, what I mean to say is secretarial due diligence mandatory?
Not really, sir. It is like the SEBI guidelines does not specifically talk about the secretarial due diligence, but it, as you rightly mentioned, sir, it talks about a merchant banker conducting a due diligence.
Correct. Correct.
And as Bala sir, at the time of discussion of your types of due diligence,
Yes.
like the way Bala sir has rightly pointed out, when we are talking about a particular due diligence, we are just not conducting that due diligence, but it is just our focus area is on that particular due diligence. So in similar lines, when we are talking about SEBI mandated due diligence, here only a merchant banker is mandated to perform a due diligence. Depending on the nature of business, the industry into which the company is running, we have to, like, as we spoke about your sector specific due diligence, depending on the sector or the industry that the business is into, we will have to take care of all the compliances relating to that, not in particular secretarial or compliance due diligence.
So it would be at the discretion of the company to do a secretarial due diligence, especially in the case of mergers and amalgamations when you do not know what you are taking on.
No. Secretarial due diligence also will be done. It will actually throw out what are the non-compliances. And when the report goes to the SEBI, unless on those non-compliances, if the rectification action taken, wherever it is required, continuation of delay or compounding application, etc., and other things are all done, then only merger will go through. Otherwise, merger will not go through. 100%.
But
If
SEBI
I can
will
add a couple of points here. So
yes.
in the SEBI's scheme of things, at least to give you one example, for instance, SEBI issue.
Raghav, could you come on video also, please?
Yeah, give me 1 second.
Thank you.
Yes, sure. So I was saying that, for instance, SEBI issue and listing of non-convertible securities regulations 2021. If you look at, that's the most recent regulation of SEBI. There is a clear-cut set of guidelines and duty imposed on the venture trustee to conduct a due diligence and the disclosure of the same in the offer document of debt securities. Just to give you one example. So in terms of what should it cover, etc., you can go and check in terms of what SEBI mandates the venture trustee who's conducting the DD to cover in that exercise. That is one. If you look at the listing agreement itself, there are these regular secretarial audits which are prescribed by SEBI every now and then under various different scenarios and situations, and obviously at different intervals. Now that again is nothing but some sort of a diligence only, which is put up for the benefit of the investors. Third is the kind of regulation that SEBI has put up for merchant bankers who are taking companies public, right? They have to give SEBI certain confirmation saying that they have conducted diligence on the company. Now, that's the reason why they end up, formally engaging law firms and other service providers and professional agencies to do a proper due diligence on the companies that they work with as merchant bankers. And then the other category is, if I can say, the due diligence coming from, again, SEBI, ICDR plus listing requirements is when some of these event-based things are taking place. For instance, takeover of a company, open offer situation, SEBI under SEBI takeover regulations, for instance, or if there's a related party transaction happening, or if there is a M&A happening without consideration being paid in cash for a cashless transaction, and there are certain other circumstances. In all of these cases, there is also this responsibility cast on independent directors, audit committee to sort of exercise its own discretion, apply its mind, go through the transaction in detail for the benefit of all the minority shareholders and unrelated investors. So how do they achieve that objective? I mean, they have to do that through this exercise of a formal engagement with the law firm and other professional advisors to conclude the exercise in a professional and formal way. Would that answer your question?
No, not fully. Raghav,
Haji.
Haji.
Dipti,
Yes,
yeah.
Dipti. Yes, Dipti.
Sorry, Mr. Raghavendra, for being late. Little I had some own meeting. That's it. See, Sailesh Bhai, in the case of anything, when we say secretarial due diligence, we talk about shares, ownership, directorship, which is the heart of the corporate. So any corporate action will affect IPO. We have to trace each and every share, how it was issued, whether it is valid, right issue. So that's why secretarial become very part. It's a prime DD because you work out valuation, you work out the goodwill, IPR, everything. But you acquire the ownership. That ownership itself is a question. Then your entire other DD is of no use.
I think you're very. I think Dipti, you're very right. In fact, in a prospectus or a letter of offer, there is that one maybe 2-3 paragraphs into how the capital has grown. You know, you have to disclose on this date this much issued, that date that much issued. There is a paragraph or one or two paragraphs, and I think that is exactly where secretarial audit actually comes in. Secretarial due diligence actually comes in.
Because even the past, sorry, yeah.
And as Bala mentioned, to check in the case of mergers and acquisitions to see whether there are all ROC filings, etc., have been done properly, so that we do not get very surprises later on in life.
Not only that, what exactly is the legality and validity of the shares, the independence of directors, past corporate action, whether that corporate action is valid or not, whether it has complied or not. It's very important for all these corporate, for other future corporate action. So it's a very heart of any corporate action. So it should be there.
So Dipti, what you are saying is that those SEBI mandates only due diligence and does not go into financial due diligence, legal due diligence, secretarial due diligence. It really encompasses all that. That's what you're saying.
You are absolutely right.
You are
absolutely right. Your understanding is perfectly correct. To add one more thing is that I mentioned in some of the earlier session also, I was with a group of Vodafone group of companies. And the Vodafone group of companies, when they actually got merged, about 12 companies in one company, one of the things which was directed by the NCLT is get the due diligence certificate for these companies. When they have done the due diligence for these companies, almost about 3 of the companies, there were a lot of secretarial non-compliances which were actually warranting to be rectified. So when that has been actually thrown out, immediately the person who was, that is the legal counsel you are looking after, NCLT will not hear the case until these are all rectification action is actually taken. And not only that, ROC going to come there, he will raise a serious objection on this matter.
So who signed that due diligence certificate? That means MCLT asked that the due diligence be done and a certificate be produced.
Yeah,
that certificate was
from the independent persons. We appointed the independent legal counsel, who's secretarial people who are working with them. Basically, the secretarial people who are working with the legal counsel, they have done the
okay.
That is what it has happened. Ultimately, I can share with you one more thing also. For this is a merger which took place almost about 4 years actually. People talk about merger going through in 1 year, 1.5 years, etc. It took almost about 4 years. Yeah, because in the process, almost something around 35 compounding applications were required to be filed. And about 5 condonation of delay application have to be filed. So this was the issue. Once all the things have been done, then we'll have to also go to the ROC. They'll have to sit with them, spend time, we'll have to satisfy each and every action has been addressed as far as the show cause notices are issued. Then only he has given the no objection certificate for this merger.
Would have been an accounting nightmare also.
Accounting is, you don't think about it.
When you go from 1 year to another.
Not only that, every time the time passes, then latest audited financial statement is required to be produced.
Correct, that's right.
That is another issue.
Yeah.
And again, post-merger, consolidation was a very, very big issue.
Okay, Ms. Patnaik and Raghav, thanks. Back to you.
Okay. All right. So now moving on. we talk about how do we plan this due diligence process. Planning is very important. Be it a due diligence or any activity that we undertake, planning is of utmost importance. So the first thing that we need to take care of is we need to understand the scope of work. Now, what is the scope of work? Scope of work and the focus areas. So in just the initial session, we have already discussed when we are talking about due diligence, it's just not secretarial for that matter. It involves a whole lot of due diligences. So here the scope of work is the ultimate outcome of this due diligence process, what is wanted from or wanted by the prospective buyer. So we understand the scope of work and we identify the focus areas which needs to be focused during this process. We will be taking care of each of the things, but there are certain things which needs to be taken care of in detail. A little more detailed analysis has to be taken care. So here we understand the scope of work, we discuss about the focus areas, and then we decide the team and allocate the responsibility. The importance of deciding the team here is, if the focus area is on a financial DD, we would obviously want a financial expert who would be heading the team. Similarly, if it is on a secretarial or a compliance point of view, we would want a professional who is in full form to understand the compliances to lead the team. And similarly, the responsibility is allocated on his shoulders, and then the team is prepared for the due diligence. Now, then we talk about well-timed information. Now, information here, what is understood is the things which are provided by the target company to the service provider who is conducting the due diligence. One very important thing to be taken care of here is, as a person who is conducting a due diligence, we should also practice special diligence in this process. We should not blindly follow what has been given to us. We should also be in a position to judge whether the things provided, the information, the records of the company are true in the right spirit of law. So here we also have to give our own expertise. We have to be more diligent when information is provided to us, and then we go about the due diligence process. Now, talking about stages of due diligence, there are 3 stages. First is pre-diligence, then comes the diligence process, then comes the post-diligence. So pre-diligence is before undertaking the process, there are certain things that we need to follow. Diligence process is what all things that we need to do during the course of the procedure. And post-diligence is the discussion that we've already had, that is relating to rectification. The findings during the course of due diligence, the rectification of those findings. Now, talking about pre-diligence.
Aditi, I will just add one point here. If you can go back to the previous slide.
Sure.
Once you finish your exercise of DD, there are remedial measures that you just talked about, right? The post-diligence, CP, CS, things to be fixed, deal to be changed, and all of that. There is also a bigger fundamental issue which it will guide you to, which is that a fully properly done DD is the basis for making that investment, whether to acquire something or do that transaction or go ahead with it. Now, there could be certain instances where once you finish this exercise, you may even realize that this is not something that is possible to go ahead with. So it can be as basic as that, not because somebody misrepresented or anything. So the management or the seller, the founder of the company probably did not even know that a deal cannot be done. I'll give you one example, right? So if it is a regulated sector for foreign direct investment, you have to make sure that you actually either are allowed to make the investment either with government approval or within the limited investment percentage and things like that. Or you may not be even allowed to make the investment if it is a prohibited sector. And if the business is actually on a borderline where that determination is becoming difficult, you will get to this analysis and finding only when you have gone through this exercise. So in most of the cases, maybe that's not the case, which is basically we will identify big issues and then find a way to deal with them. But this can be a non-starter. I'm only giving you an example in terms of legal and secretarial point of view, right? So, and there could be similar ones from business perspective, because whatever assumptions that business plans that the parties may have looked at and agreed upon before taking it to the next level, the bigger picture becomes clearer only when you have gone through this, painstaking exercise of a proper fact-finding analysis, due diligence. And there could be, then you may realize that some of those assumptions were completely wrong. And then, whatever price we intended to pay may no longer make any sense at all. So what you thought is worth 100 rupees can be worth maybe just 10 rupees. Then whether you should go ahead with that just because you thought it was not what it was, that's how it will evolve.
Okay. So now talking about pre-diligence. Pre-diligence is a process where we primarily look into the activity of management of papers, files, and people. So first thing is a letter of intent or the signing of a non-disclosure agreement or an engagement letter. Now, this non-disclosure agreement is between two parties. Here, there is no specific party that it is basically signed between the parties who are willing to undertake that due diligence. So here it can be the target company and the prospective investor, the target company and the prospective buyer, or the buyer who has got into a service provider to conduct the due diligence. So non-disclosure agreement is important here because during the course of due diligence, both the parties are in a position to disclose all the internal information about a company. So this report or the information should not be leaking out until and unless it is mandated or it has to be presented before any regulatory authority. After an engagement letter has been signed, then a checklist of documents is shared with the target company, and then verification of documents takes place. After verification of documents, there is a concept of a data room. A data room is created by the target company. Now, when we talk about a data room, there are two types. One is a traditional, one is a virtual. But in today's scenario, because of the pandemic, because of 2 long years where we all have been working from home, a virtual data room has become very important. So it is basically one place where all the documents pertaining to a company has been stored, and the person who is conducting the diligence would not have to go about places looking for documents and just refer to one place from which the documents can be taken, records can be checked. And then after having gathered all the documents, we go on to identifying the issues. Here, as we discussed about rectification earlier, first the issue has to be identified, whether it is rectifiable or not. What is the nature of risk? Is it of a high risk, of a medium risk, or a low risk, or no risk at all? So there are different types of issues that we come across during this process, and accordingly, we give them a ranking. The ones which are of a very high risk has to be taken on priority. Similarly, medium, low, and some non-compliances which do not impose any risk or probably which are not rectifiable are to be identified. Now talking about a few points which is to be kept in mind during conducting a due diligence. These are the practical problems that we face when we are going about conducting a due diligence. So why we talk about deadlines or timelines here is when we do not delay deadlines, because deadlines is something which makes both the parties comfortable with each other because it's ultimately a mutual agreement. And then we should be providing them with a specific checklist for each of the documents that has to be checked. In case something is not applicable, we just put it as not applicable. And similarly, if there is any issue which cannot be resolved, then we need to let the target company know about it. So here, when we are talking about issues which cannot be resolved, one practical example I can state here, that is about minutes. When we go about conduct of due diligence, we have to check minutes. And once minutes are signed by the chairman, it cannot be altered at a later stage. So here, these are the issues which cannot be resolved, but however, in the future, it should be taken care of. Then a few things like putting a single contact point so that we do not face any issues in the accumulation of documents. Then an overview on the placement of files and the introduction to the point person. So here basically there are two people who are coordinating. One is the person who's providing us with the documents, and the other one is the party who is conducting the audit. So two people are coordinating with each other, and we have a team in between who's working for the audit, for the due diligence process. Now coming to the main stage, that is conducting the due diligence, and in specific secretarial due diligence. So talking about secretarial due diligence, the services, the first and foremost things that we as a external independent party, we check are the minutes of the company. Now minutes are the things which are the recordings of the meetings of the board of directors that has to be mandatorily required to be maintained by a company. Now, in practical experiences, when we go through minutes, we always feel that if the minutes are there in the minutes book, it is in the perfect shape and size. But it usually doesn't happen that way. Supposedly, I would give you an example, that practical example. Secretarial standards has been mandated by the MCA for each of the company that is in incorporation, has been incorporated today. So very minute things are to be kept in mind at the time of drafting of minutes. Very normal non-compliance that we usually come across is your numbering of minutes. The numbering of minutes, consecutively numbering of minutes, is something which has to be mandatorily followed, so that at a later stage, we are not able to put in new pages to those minutes once they have been signed. We also have come across a situation where the numbering of minutes have been done in a pencil. So the same thing was reported to the ROC, and the ROC was of view that why it has been done in a pencil, because it can be erased at a later stage. But now the target company is of the opinion that there is absolutely no point, there has been no written thing that it has to be whether in done in.
Maybe I'll call you in the evening. Huh? Okay.
So there we do not talk specifically that it has to be numbered in a pencil or a pen. So the ROC was of a view that no, it is something which is not to be erased. So these are the minute things that we need to check. Similarly, when we talk about a private company, a due diligence being conducted on a private company, which is a non-banking financial company, NBFC. So here what the Act is saying that the constitution of an audit committee is mandatory, and the chairman of that audit committee has to be present in the general meeting or the annual general meeting. In similar lines, statutory auditors are also mandatorily required to attend the meeting, annual general meeting of a company. If they are not attending, they have to seek an exemption from that. So on perusal of the minutes, we come across situations where from outside everything looks good, but when slowly we enter and we check, these are the small non-compliances that we come across.
Aditi, many company, in a private company, when you mention, people think the statutory auditor is required to be invited only to the annual general meeting because the financials are considered, which is not the case. The law says the invitation is required to be sent to all the general meetings of the company to the statutory auditors. Invariably, many people, they don't notice it, they actually miss out. Definitely, this is the non-compliant, as you rightly pointed out, which will definitely invite show cause notices, which will emerge in the filing of the compounding application, etc. That will come up, which is a risk. Yeah.
These on perusal of the minutes, these are the small non-compliances that we come across. and which becomes a matter of concern for the target company going ahead into any big business transaction. Likewise, when we are reviewing public documents like the Memorandum of Association or Articles of Association of the company, every company, be it a small company, big company, or a medium company, that is all governed by its memorandum and articles. Now, again, we come across practical aspect here is when we go through the object clause of a memorandum of association of a company, there are certain objects which has been prescribed. Now, on perusing the minutes or perusing the records, we find out or we discover that the company is into a different line of business. The company has ventured out from the main objects and it has gone on to doing other things as well. So here there is a deviation. Here the company or the target company on whom the diligence is being conducted has to be made aware of this, that everything that has been described in the MOA, object clause of the MOA has to be thoroughly followed. This was just a practical example, similar in similar lines.
That means you are talking about doing a business which is actually ultra-virus from the
Ultra-virus.
association.
Exactly, exactly. It is ultra-virus, the memorandum. So in similar lines, when we talk about articles of association, because memorandum of association, article of association, these two are the governing documents of a company. So company is governed by these two internal documents, and these are public documents. So articles of association also is in strict lines with the Companies Act. But nowhere it has been mentioned that articles cannot be stricter than the Companies Act. So again, a practical example, when we talk about meetings of board meetings, notice of board meetings or notice of shareholders meeting. As has been prescribed in the Companies Act, it is a 7 days notice for a board meeting and a clear 21 days for general meetings. But in certain articles of association, we have stricter clause wherein they say that there should be a 10 days clear notice for board meetings. So when we go through the notices, the issue of notice to board of directors, we find out that this timeline as per the Companies Act has been met. But here there is a non-compliance of the articles of association of the company. So these are the small things, or rather non-compliances, that we come across when we are in the process of conducting the due diligence. Similarly, there is a statutory register, the notice, agenda, and notes to agenda. A very important thing here to be discussed is your minutes, draft minutes and final minutes. Secretarial standards very well prescribe that draft minutes as well as the final signed minutes has to be circulated to all the board members. And the reason behind this is when a certain draft has been approved by all the directors, in similar lines, the directors have a right to check whether those minutes have been finalized or not. So after the conduct of a meeting, within 15 days, a draft minutes has to be circulated. Then after the signing of the minutes also by the chairman, the final signed minutes also have to be circulated to the board members.
Many companies miss out that point actually, because they circulate the draft minute, they get it approved, they get it signed.
Exactly,
then,
sir.
in a smaller company, which it doesn't happen, which is the requirement.
Exactly,
and
sir.
Similarly, when you're talking about the registers, there are changes which is taking place between the directors and the KMPs. Registers are maintained, but at times it is not updated.
Exactly, because so
when
whenever
when the audit takes place, when the auditors calls for it, then they start updating it. The year end they submit it.
Yes, sir. Because whenever a transaction is taking place, simultaneously the registers have to be updated now.
Yeah, it should be on an ongoing basis. Yeah.
Exactly. So that the company is aware of what is happening. Like the stakeholders are aware of the transactions or the changes or alterations taking place. But many times we come across auditors coming in and the updation taking place.
Correct.
So
That's right. You're right.
So similarly, talking about records and reports and dividend, corporate social responsibility. Now, why dividend has been specifically given in a checklist? Because dividend is something which involves a lot of compliances. Companies Act has specifically prescribed to be there should be a cutoff date when we talk of dividend. The shareholders who are entitled for dividend have to be ensured that they are the ones who are getting the dividend. A separate bank account has to be opened. Then the dividend has to be transferred within a specific time period. So all of these compliances, whenever there is either an interim dividend or a final dividend declared, we'll have to check all of these things are in compliance or not. CSR, that is corporate social responsibility. Corporate social responsibility is growing in importance, and companies wherein these are applicable have to mandatorily make a disclosure in the annual report regarding the corporate social responsibility and the assignments that they have handled. Then when we talk about returns in ROC filings, here comes a very important portion, as we had discussed prior that about rectification. We come across many situations where the company has passed specific resolutions, but adequate filings is not done with the registrar. A very valid or a very practical example that we are coming across nowadays is MCA, the Ministry of Corporate Affairs, has come up with a new notification because of this pandemic that we are required to file a MGT 14 for every general meeting that is being conducted through a video conferencing. So whenever a shareholders meeting is being conducted through a video conferencing, be it an ordinary resolution or a special resolution, a MGT 14 is mandatorily required to be filed by the company. Prior to this, it was only filed for special resolutions. But in many cases, we come across situations where the companies are not aware that this is to be done.
When you talk about the dividend, if you are all maybe aware, after the IFRS has come, the preference share capital has been actually classified in the IFRS as the long-term borrowings. And similarly, when it is actually the agreed percentage of the dividend is to be paid, because normally the preference shares are issued 7%, 10% dividend. So they say it is actually a financial cost. There is actually a misnomer that since it is a financial cost, it is charged to the profit and loss account. The dividend approval is not required to be taken at the shareholders meeting, which is very wrong actually. Because what happens is the dividend term itself is says this is the appropriation from the profit. If you make the profit, you declare the dividend, otherwise preference shareholder don't get the dividend, but if it is a cumulative, it is again carried over for the future year's profit.
Next.
So it is a declaration from the profit. Although in the IFRS, the treatment is actually a financial cost, although it will be charged as the financial cost in the financial books, when it comes to the secretarial, it has to go through the approval from the shareholders, which is required. In some of the companies I come across, they miss out. That is also there. Yeah. And one more thing, Aditi, there is a chat box, there is a question is there. How much material is a non-compliance with the SS1 or SS2 in the process of due diligence? You may like to address.
1 minute, sir.
There is a question has been actually put by Amit. He says, how much material is a non-compliance with the SS1 and SS2 when the process of due diligence?
Yes, sir. So when we are talking about the materiality of non-compliance of secretarial standards, there is a penalty that is imposed on the company. It is 25,000, and the officer in default is also liable to a penalty of 5,000 here. The
SS1 and SS2 being made mandatorily, it is as good as the Companies Act itself. It is part of the Companies Act. Any non-compliances will actually invite the penalty for which there is a prescription is there, if I'm not mistaken. Yeah.
Yes, sir.
Yes, Aditi. Yeah.
Then talking about ROC filings and returns. So we sometimes come across situations where resolutions have been filed, but then they have resolutions have been passed by the board, but there is a failure in letting the registrar of companies know about it. So in case we are coming across such situations, then there is a rectification that can be done on a later date. Similarly, related party transactions, director and KMP, shares and securities. So when we talk in particular about related party transaction, It has become one of the most important aspect in a business entity. So adequate disclosures related to related party transactions have to be given in an annual report. In similar lines, AOC2 has to be disclosed, and the auditor, even if it is according to accounting standards, the auditor in the financial statements have to give a audited value of the related party transactions that has occurred during the year, and that has to be again checked with the minutes whether the same has been approved by the board, and if it is crossing the limits, if the same has been approved by the shareholders or not. Now, talking about directors
Ms.
and
Patnaik,
KMP.
Ms. Patnaik, if we just go back to that question, Bala, about how material is non-compliance with SS1 and SS2, I would say it's very, very material, because if you are not compliant, see, SS1 and SS2 cover board meetings and general meetings. Now, if these meetings have not, it talks about how those meetings have been convened, how the resolutions have been passed. Now, if these have not been properly convened or resolutions not properly passed, then there's a very great risk of them being invalid. And if these resolutions are invalid, well, you can have tremendous consequences. So non-compliance with SS1 and SS2 is of great consequence.
May I just comment? This is Amit. This was my question, sir.
Yes.
It was meant by non-compliance of SS1 and SS2 means that, like, which have SS1 has mandated that first of all, your draft minutes have to be circulated within 15 days of the board meeting, and then signed minutes are to be circulated after 15 days of signing the minutes. So my question was whether if the company secretary has forgotten or has not complied with this, so will that vitiate in any way? Will that vitiate the process of due diligence? Will it have that much of material impact? That was my query, sir.
Okay.
It will not vitiate the due diligence, but the thing is, they will assess, as Aditi puts it, what is the rating of the risk, whether it is a high risk, it's a medium risk, it's a low risk.
Yes,
that is the rating she will give. The moment she give the rating, she will also give the impact, likely impact. What is likely to be the penalty? Now, what happened? The due diligence process, ultimately, he has to take a call. If these are all the things are all going to be the future liabilities, he will have a better negotiation point doing 1, 2, 3, 4, 5. These are the possibilities of the future liabilities which are there. Your price will get reduced to that extent if you have to go into the deal. That will be the impact which will come out.
Yeah, so that has to be negotiated. That this much will be the monetary or the financial loss on the company. And then if you are the purchaser is agreed to do that, then only we can proceed with that.
Correct, correct. You are absolutely right.
Okay, and in the internal report to the management, these things should be brought out so that you are not accused of incompetence or correct. All those things are not there. You may not put it in your final report, but put it in your internal report to the management.
Not only that, I also seen in the company where the due diligence has taken place, but the deal is not gone through. But the thing is, the company was definitely interested in rectifying all those things which came out in the due diligence. What they have done is they have actually, all the same people who have done the due diligence, can you actually help us in rectifying these actions? And the people who are associated with them, they have done to the extent wherever the rectification is possible, they have done. Wherever the compounding application is required to be filed, they are assisted in filing the compounding application, etc. That also taken, it throws out another, area of the practice for the practicing company secretaries.
Okay.
So, Amit, a modified response to your question is that it would depend upon the classification of that you do, high risk, medium risk, low risk, etc. But even if it is low risk, my view is that it should be brought out in an internal report to the management.
Correct.
For example, in the board disclosure, there are a lot of board disclosures are required. If the board disclosure is not required, then again it is a violation.
Right.
That will actually call for the fine and penalties. And similarly, when you talk about the financials, the significant accounting policies are required to be disclosed. Correct. Segment accounting is to be disclosed. You may not have the segment at all, but you have to address that we are actually not covered in the segment accounting, as she rightly put it. It is not applicable in our case. That has to actually come out. If that is not the case, it's a problem. And not only that, I have actually come across in some of the companies, which is not typically, office company, not the manufacturing companies. They don't talk anything about, what you call that energy conservations. Energy conservation, they don't talk about anything.
Correct,
But
correct.
there has been issue. It has to be addressed. It is not the
That's
energy
right.
conservation, not there. Even in the offices, whenever the lights are required, fans are required, ACs are required, it is required to be put. We have to conserve the energy. And what is the action is taken, which is a specific question which has been done. But they simply think, oh, we are not the manufacturing industry, it is not applicable, which is not correct again. There has been show cause notice, the same companies where I referred, the amalgamation companies of 12 companies in the Vodafone group. It has happened in one of the companies. There is a severe penalty has been levied because of the non-disclosure in the board report. So these are the impact will actually come out. Yeah.
Correct. Thanks a lot.
Go ahead, Aditi.
Okay.
Shailesh Bhai, you are telling something. I think I interrupted.
No. I completed whatever.
Okay.
Now shares and securities. Shares and securities, now unlisted public companies are mandatorily required to dematerialize their shares. So the entire responsibility is shifted to the registrar and transfer. Now, when we talk about shares here, for a small private company, whenever there is an internal share transfer, there is no requirement of filing the return with the ROC. But yes, here there is a requirement of a execution of a share transfer deed in the form SH4. So many companies, what they do is they pass a board resolution. There is no requirement of filing of a form. So for all practical reasons, they feel that they are compliant. But no, here very necessarily we need to execute a share transfer deed. And in cases of securities which are already dematerialized, the registrar and share transfer agents need to take care of that. So there are many other cases and many other things and other points that needs to be considered when we are doing a due diligence process. Now coming to the reporting portion. After the whole of the process has been conducted, after we are able to analyze the current situation or scenario in which the target company is into, we have to provide our report. As rightly identified earlier, it has to be called a report. It can be a summary report. It can be a detailed report. It can be a report nature. And similarly, the findings has to be made available to the findings have to be made available to the management of the company to make a proper understanding of the situation. Now, basing on this due diligence report, we come to a situation whereby this also we have priorly discussed. Due diligence is a process which can make a deal go through. It can break a deal, it can dilute a deal, and at the same time, it can be treated as a deal cautioners. So breaking of deal is when both the parties understand that maybe the objective is not aligning with each other, or maybe they are into a merger or amalgamation with a too much non-compliant company. So there it can lead to a deal breaker, a deal diluter, a deal cautioner, and a deal maker. Deal maker is obviously when we have a clean report, something which we understand is a company is not non-compliant, and even though it is non-compliant in certain areas, there are areas which can be focused upon and it can be rectified. So now talking about post due diligence, once the process is over, once the report has been issued, now it is the responsibility of the person who's conducting the audit to take care of how the non-compliances which has been discovered during the process to make it good. So it results in rectification of non-compliances during the course of due diligence. This also we have, the way we have discussed, it can lead to a condonation, it can lead to a compounding of offense, it can lead to a adjudication. We will maybe have to advise the target company to make applications or file petitions into the ROC, and then we can make good the loss which has been done during the course of the due diligence. The findings which has been brought out to the eyes of the management, those have to be made good. Now talking about finally, when we talk about due diligence, it is like one of the most favored method to gather information about the target entity and the market conditions. So due diligence is something which is done so that two entities who are either wanting to merge or any of the business transaction that is supposed to take place between two entities can be a detailed analysis of the situation can be made, and an informed decision about the same can be done.
We have certain questions in the chat box.
Yes, Neetu.
Yes. So one question is, how much material is a non-compliance with Secretarial Standard 1 or Secretarial Standard 2 in the process of due diligence?
That question has been discussed.
That's been answered already.
Yeah.
And okay. Also, one question is asked that how much due diligence is enough?
No, before that, there's another question. With respect to mentioning the page numbers of the minutes paper, it is necessary to mention, is it necessary to mention the page numbers of the blank page, which is the part of the minutes or not, whether we mention the page numbers as 1 of 20, 21, 21, 22, etc. Now, the question is, the blank page, as per the secretarial standard, is required to be striked off and it should be initialed by the chairman. Earlier, much before the secretarial standard, we used to strike up. Now the secretarial standard says it is also to be initialed by the chairman. That is one. Second thing is the page numbers numbering. It is up to you actually, because the secretarial standard left out the different ways of the map. I think somebody has already replied on that question to you. It's saying actually not required to mention the numbers, the blank pages, such pages to be striked off and written mentionly left blank as the case may be. Style of mentioning the numbers.
Bala, the secretarial standards do give 2-3 methods of numbering in an illustrative box.
Correct. You're right. Absolutely right. Yeah. So the company, whatever the practice they want to follow, they have to do it accordingly. Whether they want to follow the year, they want to find the committee, they want to follow whatever the numbering.
That's right.
Whatever it is, they can decide. It is left to them. But illustrative things have been actually spelled out in the secretarial standard. Then moving forward is various methods of pages have been, numbering has been mentioned there. The last question, Neetu, you read out. How much due diligence is enough? I really didn't understand the mind of the person who's raising the question. He is there. Can we hear from you, Vishal? What exactly you are asking? How much due diligence is enough?
Hello.
Yeah.
Yes, sir. Yes, sir. Vishal.
Yeah.
Sir, actually, my question is how much due diligence is enough with regards to materiality and key findings and timing of the due diligence?
See, timing, as she rightly said, the deadlines are agreed between the person who's assigning the due diligence, the person who's conducting the due diligence. Because time is always the essence for a particular transactions. So time is of the essence as far as this is concerned. But given the time, if the due diligence is required to be done, then again, adhering the schedule, making the material available, spending the time, again, if they want to seek the clarification, etc., that is very much important. If those things are not happening, then you will be missing the deadline. Then again, one of the things might happen, if you miss the deadline, they may not be interested in going through the deal, or the time of the essence deal itself will get lapsed. Because much will depends upon what is actually the mandate which has been given, what is the scope is actually required, what is the time is available at your disposal. That is what it is agreed. There's a pre-diligence, what she talked about, of course, very important from there. Yeah.
Also the quantum of fees, Bala, because if your fees are very meager, I'm serious about it. If the fees are very no, please, I'm really serious about this.
Of course, it is. It is important, yes. But
if the fees are meager, you cannot go into a very detailed due diligence. And that could be a matter of defense in case something crops up later on. But if you are paid very well by way of fees, then a greater responsibility is cast on you to do a greater and deeper due diligence. But Bala, I have another observation.
Yeah.
You know what I feel is that if you have to do secretarial due diligence,
yeah,
one should appoint the secretarial auditor for the secretarial person for this, who is different from the regular secretarial auditor. A due diligence auditor should be different from the regular guy, because
you are absolutely right, Shailesh bhai. In fact, I will share with you one thing. You remember we are been talking all the applicable laws to the company.
Yes.
This concept has come in the Companies Act only after 2013.
Yes.
But much before that, SEBI has actually brought. Okay. When the SEBI has actually brought for the first time all the applicable laws, when I was working in a company, listed company, the very first thing I did is I altogether located a different person who's actually a practicing company secretary. I told him, you come here, you meet all the departmental heads, you meet all the manufacturing heads, you meet the marketing heads, you meet HR head. Please prepare the list of laws which are applicable to this company. That is what I given the assignment long time back. In fact, he did a wonderful job. We had about 2 manufacturing units, one is at Pune, one is at Pondicherry. He prepared the list. It is a small, medium-sized company of doing about 300 crore turnovers, manufacturing company, chemical manufacturing company. He could identify at that time, I'm talking about almost 20 years back, 85 laws in respect of Pune, 92 laws in respect of Pondicherry. I asked them, why this Pondicherry it is more? He said, your factory is situated in a village panchayat area. There is some panchayat commune law which you need to comply, which is there. In Pondicherry, you actually put up the generator. There is actually a state law. When you are generating generator, you have to pay some levy for that, and you have to actually file the return. That is why that law is become applicable. Like that, he brought out the differences. Again, he said there is a coastal area in Pondicherry, Pune, which is not the case. So there specifically your coastal area rules are applicable there. Like that he gave. Then next question I asked him, does it cover all the laws applicable to this company? He said, I cannot answer this question to you. I have covered to the best of my knowledge what I could identify. There is a possibility something would have missed out. I do not know. I cannot say 100% it is a full proof. I cannot say, which was rightly the right answer. And subsequently, when we gone along, then we added few more laws as we come across. I always used to tell the board, this is the exhaustive list we have prepared, but I cannot say it is a 100% list. This is the case. Because when we talk about all the applicable laws, the first thing is that all the applicable laws applicable, we should be aware of it. Then only we can go through. Second thing is asking this, what I have done is, that time secretarial audit was there. I have appointed somebody else other than the secretarial auditor to go into the compliance of the all other applicable laws, including the secretarial law also, and give a separate report to the management for the purpose, not for the mandatory or statutory purposes, but to know the companies. That also I had done actually. In fact, in one of the balance sheet which is published earlier, those year period, that report given by the independent auditor for all the applicable law, that is also finding a place in the annual financial report which you have published at that time. You are absolutely right.
Because, you know, my view is that if there is not too much of a difference, and Dipti may correct me if I'm wrong here, there's not too much of a difference between secretarial audit and secretarial due diligence. And therefore, if the same guy does both the things,
he will take it for granted.
Huh? Yeah, it is taken for granted.
He'll take it for granted, that's it.
That's right.
Yeah,
that's right.
I will little say that secretarial audit and secretarial due diligence. So far, I will say Mehta&Mehta. Secretarial audit, we, as you know, Shailesh bhai, we cover very vast. We cover sector specific, we cover, you know, HR and many other things. Also, what happened in secretarial due audit, we cover that period limitation. But when we do due diligence, we go for tracing till the starting of incorporation. And the trust is more on secretarial, and in secretarial, I'll say audit, we presume in past the things are done correct. And we take that kind of management represent. But in secretarial due diligence, we do not presume, we have to check till end.
Okay.
This is a major thing. Mr. Raghavendra, your point on the subject, what we are discussing at present, if you have any view.
Well, Dipti, this is a little more in detail and more nuanced. And I must say, honestly, I mean, this is very technical, and I have sort of become more of a manager where, managing the process has become more important here to me, and then finding solutions. So by the time it comes to my table, it is almost a issues list where we have to deal with the problems at hand. So I would say, I have limited experience here.
Okay. Yeah. There is in chat one question about secretarial standard, how it is. Shailesh, you would like to answer that question?
Which one?
In chat box, there is a question that how it will be, the question is, with respect to mentioning pages, it is that if secretarial standard is not complied with, like it is how much material is the non-compliance with the SS1 or SS2 in the process of DD?
Bala and I addressed that.
We discussed that.
Okay.
Yeah.
Okay, sorry. Yeah.
I don't think anything is pending in the chat box unless
that's right.
People have the query.
No, nothing is there. Yeah. I think Aditi, your presentation is
but just I'll take one point.
I can ask you a separate related question, in fact. So in how many cases in your own experience have you said no to take up an assignment because you felt that there's too much of gandagi there?
No, actually, when we do due diligence, we don't know in advance. So we carry out due diligence, and always there is a problem and a cost and the solution. Then comes the solution and the effect, commercial effect or otherwise. In certain cases, yes, 2-3 cases, the grievance, what you say, the problem would be as regards the ownership and legality of ownership. There we have done a red flag. And then we advised also adversely in DD. But in majority cases, there are very grave situation of non-compliance also, including famine and all that. But everything is not, I will put it that way, that it's, if it is not like a murder, then it can be solvable with the penalty, prosecution, compounding,
no,
and some
so let
solution.
me refine the question. So have you had an instance where you actually start the assignment and realize that the compliance has been a disaster, zero compliance, or it's all over the place, not done properly? Then suddenly the promoter says, don't issue the certificate, I don't want to do anything about it. And then you sort of withdraw from there. Has sort of a thing happened anytime with you?
In due diligence or secretarial compliance certificate?
Both, I would say, or either of them.
Yeah. In secretarial audit, we have faced this. In one of the case, actually, I will put that when one of our partner was president of institute at that time, because we always visit plants of the company. And the same, I always explain, our firm explain the entire process for half an hour in that if we will follow that, if you are agreeing that, then only we'll start the process. He agreed, and later on he says that I finished my secretarial portion. I said, now my operational factory audit starts. So we'll visit. So he said, no, our partner is objecting, director, people don't secretarial audit, no one does this and all. I said, the same is mentioned to them. They said, we will not allow, we are compliant. I said, if you are compliant, then what is your problem? You should be confident. The intention is not to, find out a problem in you. The intention is to find out the problem and work out the solution so that we contribute, so that it helps you in future. It's not that intentionally every management or company intend to non-comply, but it's out of sight, out of mind or control. It happens, but it didn't happen. We stopped. We given the assignment back. This happened, and then many cases, I will say it was a big PSU. My secretarial audit was finalized with MD and CS at 3 o'clock in the night. And I did not I put my foot down. Though next year I was not there, but I will not do that. So we have done that many times. As regards due diligence, there is no question, in the sense we have to give suggestions only, that what you suggest. But I say that in majority cases, we have come out with the solution. There are very, drastic non-compliance and all that. Even pre-IPO due diligence, as we are expert in that, we get such a shock and all that, complaints and all that, but we work out the solutions and try to handle it. And many times it becomes impossible. We have to say, you have to disclose now, India. You have no choice. Otherwise, you delay.
The disclosure point, I think, makes all of these people really uncomfortable, and they're okay to live with the non-compliance until the investigation or ROC inquiry.
Yeah, right. But that will not.
If I may, but Raghav, the existing law does not support secretarial auditors as much as it does financial auditors. Once you have appointed a financial auditor, removal of that financial auditor is a nightmare. You just can't do it unless you do a number of things. But removal of a secretarial auditor is pretty simple. And that goes a lot towards what Dipti is saying just now. You therefore have to be willing and strong enough to say that I will report this, and if you want, you may remove me. But I will put it on paper to you, at least to you.
Yeah.
If not going public. And Dipti, I know Dipti has done this. Of course, next year you're not going to be appointed. Now, if you had been a financial auditor, a CA, it would be so difficult to do all this. For the company to do all this.
See, for the practicing company secretary to maintain higher standards, it becomes important also from another point of view. Let's say today you want to brush things under the carpet because the person who engaged you says, let's not highlight this, let's just not report this, or underplay this. Now, let's say there is a report given, taken, everyone is happy, and there is another transaction in 6 months' time, right? And another set of people coming in and having a look at the same set of papers, but with a different lens. Now, it's not just the company which is going to get exposed, not just the promoters who are going to get exposed, it's also the previous service provider who will be questioned.
Yes,
so
correct.
Kind of shows you in bad light, right? So it's very important that we do our job well, no matter what.
Absolutely.
Although I would like to share one thing, which I can recall it, but it is not with the secretarial audit or something like that. When you say, have you come across any refusal of taking up an assignment? In that context, I would like to say, some of you, even the Sailesh Bhai will be knowing. Sailesh Bhai, you will be knowing in Bombay, Sharp & Tannen, which is one of the auditors. You may be knowing that firm.
Yes.
And there was a gentleman called Bilpodiwala, who was actually a very, very senior partner.
HK Bilpodiwala. Yes.
Yeah, very highly intelligent person. And it is very difficult to meet him and to talk with him and all without appointment, etc. Because all the other junior people deal. I had an opportunity of dealing with him late 70s. Late 70s, when I was dealing with him, they were occupying the place which is actually owned by the Bank of Baroda building at the fountain area. They were actually on the fountain. What has happened? They were having an audit of the Bank of Baroda, which is having more than 400 branches across India. It was one of the audit which has been handled by them more than about 2 decades. They were actually handling it. And late 70s, the issue has actually cropped up with the Bank of Baroda. Basically, the intercompany balances were not resolved actually in the particular year, which he has shared with me. So what has happened, he told very clearly, the intercompany balances is not reconciled. So please reconcile the next year. I am giving a management letter to that effect. Next year also, it was not resolved. They said, no, we are trying our best. This is the problem, that is the problem, and all those things. That particular year, some hot discussions seem to have taken place between them and the management. He told very clearly, If at all the bank collapses, it is going to collapse. One of the reasons for non-recurrence of the intercompany balances. He made the point that year it continued. Third year also the default happened. They themselves were told, sorry, we are not interested in taking over audit because you are not interested in doing this job. I can tell you today, down the line, you are actually sitting in a very high risk. The bank will actually collapse. This is the statement he has said. In the number, Bank of Baroda is actually gone. In fact, there was a photograph which was appearing. Maharaja standing here. Advertisement were actually appearing. And I think later on, of course, they found out somebody was a HR guy. I think, if I'm not mistaken, Kandalwell. He was the person who was appointed the chairman. He revived the Bank of Baroda. There was a book is also there written by him. Really speaking, I was there in the release of the book function at the Kandalwell also, which was the reveal of the Bank of Baroda story. There are people who are high visionaries who can actually visualize, who can take the drastic decision. The question is here when you say, are you refusing it? A Bank of Baroda audit, which is about 400 branches, etc., which was actually one of the biggest audits, which is they are given up. The next thing followed is definitely bank told them, given a notice, asked them to vacate. They vacated, they moved to somewhere else. You may be knowing
this vacating part is slightly different.
Yeah.
The vacating part comes out of the Public Premises Rent Act.
Yeah.
And those occupying rental premises under old rent payments, but occupying public premises, there the protection under the Rent Control Act was revoked. And it was under those grounds that they had to move out of Bank of Baroda building.
But it followed after this.
Could be. But I think that continued having their office there until this act came, public premises rent control or something like that.
Yeah.
Yes, but what you say is absolutely correct.
I really appreciate the visionary of that particular person at that particular time who could visualize. He will actually said this is what it will happen.
Mr. Some question. He has asked about some director.
Your line is quite bad.
Criminal civil.
Dipti, your line is very bad.
Your voice is not being heard, Dipti.
There is a question from Mr. Suresh. Now it is audible?
Yeah. Yes.
Yeah.
There is a question from Mr. Suresh as regards directors' liability and criminal. So can you, Mr. Suresh, say what is exactly the question? In chat box, the question is there. I think you are referring that what to do about the liability of directors and the criminal and civil cases. I think Mr. Suresh is there.
I don't think there is any such question.
I don't see anything in the chat box.
Chat box, there is no such question.
Yeah, I don't see anything.
Okay, then. I was able to
Chat box is in front of me, but it is not there what you are saying.
It says, how can deal with criminal and civil litigation of director, promoter, directors when these cases are due to directorship? Litigation relating to promoter and promoter group company.
Maybe he has addressed to you privately.
Yeah, maybe it's addressed to
chat box.
Okay. Yeah, actually, then can you, according to me, yes, directorship, director and all that, if you know the case, of course, we have to highlight it because the continuation of that directorship and the intent and the future of the company, not only because directors' action decide the management and possible other risk, we can say, of that company. Because DD does not mean everything you are knowing to get. There will be certain hidden thing, and that's always contingency clause, and that fund also in escrow account will be there always, which will be utilized in case of contingency. So this is very important, but the only thing is provided you know that, but it is a very, very crucial point of DD, of director's liability for any civil or criminal suit as such. That is my answer. Mr. Raghavendra, if you want to add something on this part.
I think that is well covered. I guess.
I'll just say here, I wanted to just explain about that when you are going for an IPO or any some corporate restructuring, also you are appointing merchant bankers and all. They generally call all the documents and information in the process. There are certain set of questionnaire in which they ask about the litigations, whether litigations relating to directors and promoters and all those things. There are sometimes criminal litigations may exist also because of if suppose there is any non-compliance or some issues about under the Pollution Air Act and Water Act and some other acts, local laws, then because of they are the directors, they get also some notice or summons, and they are also be part of the this kind of proceedings. So the challenge is how to deal this kind of proceedings or disclosures when the merchant bankers and during the secretarial audit, if suppose these kind of questionnaires are coming to the company and the company officers. That's the only point.
I think disclosure is inevitable. So, there is no stopping of any litigation, right? So if somebody is getting sued, you can't stop that. So disclosure is absolutely important. In terms of how do you defend any such litigation against a director, I think there are distinctions to be made. So, if he is officer in default, KMP in promoter, then the roles are sort of at least to some extent slightly articulated in today's context in the latest Companies Act. I think it's 146, I forget the section. So if you're not in management, if you're not in control, and if you have attended to your duties as a director diligently through the board process, if you have raised right questions, made sure that you have your voice is heard, proper recording of the points that you have put across, all of that is tabled and minuted properly, then there is a good defense for people who are no longer running the show as opposed to people who are running the show. So that distinction, at least today, is reasonably well, fairly clear. So, but if you have to defend yourself, there is no other option but to do that. And then for that, there are D&O policies and indemnity provisions in the articles or separate agreements with the company where you go on become board member, and where the company pays for all the defense costs, things like that.
Okay.
Ms. Patnaik, one last question to you. It's not actually related with due diligence, but something which intrigued me a little bit. You see, in your presentation, which was a very good presentation and very nicely presented by you, there is a reference to due diligence being there in India in the 15th century, in the early part of your presentation. Do you know any particular example of what is this that you're referring to? In the 15th century, you have said that there was due diligence. I'm intrigued about this.
So basically what I wanted to imply here is due diligence is not a very new concept. Ever since companies have come into being, due diligence has always been there. So maybe it was not the kind of a procedure, procedure that we are following nowadays. That is step-by-step things and checking of all the documents and everything. But due diligence was always there. It was always existing way back. And it is like kind of, here due diligence does not only mean about investigation of records, but due diligence here also talks about taking care of an event. So diligence, basically looking at diligence, we are taking special care of something, and due is like before occurrence of an event. So what was basically implied here is due diligence was something which was always there. With companies being coming into being, due diligence was always in force. But now that concept, over the last 20 years or so, this concept is revolving, and it is growing in importance.
Okay, thank you. Thank you.
Okay, I think the presentation was good. Mr. Raghavendra, you said that you wanted to say at the end of the session certain points. Would you like to say something, please?
Yeah, I mean, it was well done. I guess most of the points are all well covered, but from a, buyer, uh, as a buyer of an asset, I mean, for anyone who is putting money on the table, it is important that a full 360-degree view of the things is taken off, and before you commit to the transaction, you actually take a deeper dive, because obviously why you are buying it for is for a particular purpose, and if that purpose is not really fulfilled, then obviously that transaction will result in losses for you. So the way to do that is kind of like more or less evolved into science plus art, because there is so much of softer issues that one has to look at, right? So it becomes a topic in itself if we have to start discussing commercial diligence, KYC, background verification of the promoter group, or the people that you want to deal with, technical due diligence and things like that, where and financial diligence and tax diligence. I mean, these are aspects which actually have a huge impact on making that decision, because if you just look at the financials, obviously you will never be able to know whether they are what they are, because there are different ways to look at the same information from different perspectives. So it is for the purpose for which it is initiated also becomes sort of important. So from a seller's point of view, a vendor due diligence may just be a collection of information and to be kept in a particular place. From a SEBI DRHP point of view, again, maybe just collection of information, right? So go into this as a buyer of that asset or company, you have to have an investigative mindset in everything that you take, the approach that you take there. That is all that I wanted to say, and it's been a good presentation. I think if there are questions around any of these things, I'm happy to answer.
I must say, actually, Aditi has presented very nicely, covering all the aspects. Apart from what she talked about the due diligence, many things what she brought out is utmost importance for the people, especially the employee company secretaries, in respect of taking care of the minutes, numbering the minutes, sending the notices to the statutory auditor, sending the notice to the audit committee chairman, filing the MGT 14 on transaction which is involving the board meetings, not skipping away. All those things are all very, very important. That actually shows the very high responsibility with the company secretary which has to perform. Not only that, she has also brought out nicely in the due diligence what are the various aspects which a practicing company secretary need to take care of. It is well presented, Aditi. It is actually a very, very good educative things today's session is, I must say that. Thanks a lot. Hats off to you.
Thank you, sir.
Thanks a lot to all the participants who are actually raising questions and who has actually participated, who has actually interacted. I am thankful to all the participants as well.
Thank you very much.
Thank you.
Thank you, everyone.
Thank you. Thank you all.
Thanks a lot. Take care.
Yeah.
Good weekend. Stay safe.